So, any other announcements that people need raised here before we get on with things? And I would like to invite to the podium Mr. Glenn Gerding, who is a North Carolina appellate defender, and he has represented a bunch of people. Most noteworthy, perhaps, is Mr. Buckingham in a case that we've given a lot of attention to, and it's now before the U.S. Supreme Court. But Paul has a long history of indigent defense and has served as an officer of the Navy and still in the Naval Reserve, right? So we appreciate everything that Paul... Glenn, I'm sorry, I get you guys mixed up. I'm sorry. Yeah, I'll call him Paul Gerding this afternoon now. Glenn will come up and present our discussion this morning on beating back banishment and Big Brother. And I think people can relate to that title. We appreciate everything that you are doing, Glenn, and welcome to the Narsal Conference. It is all you. Thank you.
Good morning. I'm going to try to stay in this zone here so I don't create a squeal from the mic, and so that I can stay here with my computer. I've got a lot of technology going on, so I'll try to keep things moving and active, but excuse me if I do have to celebrate. I'm from North Carolina, and many of you may have heard of the state of North Carolina. It used to be a sleeping state in the upper south, known as a vale of humility between two mountains of conceit. That being in South Carolina. We were progressive in our politics, and we were good to our people, but just probably about the past 10 years, our state has taken a hard turn to the right. We have gone off the rails, as far as I'm concerned. And now our politicians are more concerned with bathrooms than they are with poverty. They're more concerned with preventing 2 or 3 people from fraudulently voting than increasing voter participation. And as you have seen, and many of you have lived, they are more concerned with banishing people from our communities than they are with helping people and helping them to not reoffend, and helping them recover, and to helping them improve their lives and be a part of our communities. That's where I have found myself as an attorney. I am the appellate defender, so I am a public defender, and I run an office of 20 attorneys, and we represent indigent clients who have criminal convictions. Around the state, we have public defender offices to do trial work, and from the 100 counties in our state, where people are convicted if they cannot afford an attorney on appeal, which most can't, my office represents them. I've been there about 1.5 years, and before that I was in private practice, and before that in a public defender's office, and before that I was in the Navy. And it was really in my time in private practice that I started working with clients who found themselves subject to restrictions, found themselves banished, found themselves subject to the Big Brother restrictions. And I really started developing a practice that involved representing people who had these challenges and problems. And as I said, it was about 10 years ago. And I know we think about the registry coming about in the early to mid-90s in both states. But really, as the 2000s progressed, that's when we started seeing a lot of the regulations I'm going to talk about today, and that most of you in your states have experienced. So, how did we get here? And my presentation this morning is probably a little bit wide-ranging. It's not as narrow and focused as some of the breakout sessions. So excuse me if I cover some ground that may have already been covered in other presentations. But this is sort of an overview presentation within some North Carolina specific discussions. All right, this is where I try to start using these things. There we go. So how did we all get here? The couple things we're going to talk about are just generally banishment and Big Brother. But how we have gotten here has been through extreme reactions to extreme circumstances. And this is, generally speaking, the way that people respond to events. They respond with hysteria, they respond emotionally, they respond without relying on hard science. And where we find ourselves are with knee-jerk reactions to what typically are isolated problems. But there are real problems. And, real problems are what resulted in things like the Jacob Weatherly Act, Megan's Law, and the Adam Walsh Act. And those were cases where children died. And those were real events. Those were real events that we have to deal with in terms of how we interact with people in our legislatures, how we deal with the media, and how we deal with people in the community that we are trying to bring on board to understand the perspective that we have, that those are isolated events. Like an airplane falling from the sky, those are isolated but horrific events. The other side of that hysteria are the fantastical or fantasy incidents. And I've got down here North Carolina's Little Rascal case. How many people remember that case from North Carolina? It was a nationally televised trial that occurred in the early 1990s. It started in 1989 in eastern North Carolina, Eatonton, North Carolina. There was a daycare called Little Rascal Daycare, and it was a place where a child made an allegation about the owner's husband, Bob Kelly. And suddenly, one accusation turned into 90 children in a small eastern North Carolina town making allegations of sexual abuse against 20-some-odd people. This was not unique to North Carolina. Around the same time, there were similar hysterical allegations made in other states, at other daycares. And it was these type of events that caught the attention of people in the legislatures, people in the community, and everybody's initial reaction was that these children wouldn't make this stuff up. It had to be true. And that's where the genesis for the registry laws in the mid-90s really started coming. So on the one hand, you had the real incidents where children died under horrific circumstances. You had the plane falling from the sky. But you also had the fantasy hysteria that came from cases like the Little Rascals case. And that was a case where it wasn't just allegations of sexual abuse. It was allegations of ritualistic killing of babies. It was allegations of taking children on boats and throwing them in the ocean to sharks. It was allegations of hot air balloon rides. It was craziness. But at the end of the day, the jury believed the children testified after a 9-month trial and convicted Mr. Kelly, and he got 7 consecutive life sentences. His wife was convicted, and another daycare worker was convicted. There were 3 people convicted. Ultimately, all 3 had their cases overturned on appeal. And there was no retrial. And the allegations against all of those other people were ultimately never pursued. And I think that is fairly typical as to how some of these cases turned out around the country. That when it finally came down to it, there were exonerations, and the number of allegations ultimately was whittled down to single people or single allegations. So that's what we were dealing with. And this is the cultural memory that people have in your state or North Carolina, where they remember Little Rascals. And they may not remember the Court of Appeals overturned the conviction. They just may remember the hysteria that was on TV. They may remember the Frontline series from 1991, which if you really want to go back and understand how we got where we are. I found this on YouTube, preparing for this. There's, I think, a 4-part series on YouTube. It's the Frontline series from 1991 about the Little Rascals case. And to their credit, the media debunked quite a bit of what had happened in the hysteria. But still, people wound up with lives ruined. And there are people still to this day in Edenton who believe something happened. And who believe that somebody is guilty of something. And so that's how we got to where we are. The horrible, horrific, real incidents, isolated and small in number. And the hysterical, fantastical allegations that came up. And the common thread in all of this is fear, hysteria, and as we know, politics. Because if you're a judge in a small town, elected, and you're presiding over a case with allegations by small children, even if you are not consciously making decisions and rulings that favor the state, you can only imagine the unconscious decisions, your unconscious effect of your decisions, and politics being involved. And the same with electing people to your state legislature. But the reality is we have to deal with these dynamics. And we have to deal with them when we're working to scale back restrictions and try to eliminate existing restrictions or prevent new ones. And those are sort of three different tracks we have to take. We have to try to prevent restrictions, we have to try to scale back restrictions, and try to eliminate them. So how did I get here? I'm often asked that question because it's not a usual career choice to be involved in litigation involving sex offender restrictions. It's not something, except for somebody we heard about yesterday, their brother went to law school to defend their right. That probably is the exception rather than the rule. So I got here by happenstance. I was in court one day. I did in private practice mostly court-appointed work. Somebody's charged with murder, they're charged with robbery, they're charged with shoplifting. I get appointed to represent them, defend them, and sometimes that happens in court. You're standing there, the judge says, "Over here, Mr. Gerding, you're going to represent me." And we had a judge who was pretty well known for not using a list of attorneys, but rather just grabbing somebody in court. And so if you were in court that morning, and the judge was on the bench, and they were doing the first appearances, he tried to scurry out. So she would be not the one who happened to be sitting there who the judge could pair up. Not because she didn't care about the cases of the clients, but as you can imagine, we just all are overlooked. So to the extent that we could try to sometimes not be the one who immediately got pulled into something, we try to scurry out that. I didn't get out fast enough. And there were two people sitting on the front row in their orange jumpsuits from jail. And the judge said, "All right, Mr. Gerding, I want you to represent us here." And he's been charged, he's a registered sex offender, and he's been charged with some violation of restrictions. And I didn't know that North Carolina had enacted restrictions on where people could go. I probably had seen it in some continuing legal education courses or just in the media, but I had not represented anybody who was charged with this. It was that new. And so I go to meet my client, I talk to him, we try to start talking about whether he can make a bond to get out of jail. And I found out that what he was charged with doing was going to church. That he, in my mind, I'm thinking, okay, what do you do at the church? Right? Because why else would you be charged with being in church unless something bad had happened? And so, and you talk to your clients and you think, okay, there's got to be more of the story. Well, what am I going to find out later? And so I talk to him, and I go back and I talk to the district attorney, and this was in court. So I'm just in the back talking to the DA, and she says to me, "Well, I would not want to be sitting in church with him beside me on the pew." Wow. And I only know the person 5 to 10 minutes. I don't know a whole lot about the case. And because I'm trying to say to her, all we did was go to church. And her response was, I would not want to sit on the same pew with them. Now, what kind of attitude is that? Exactly. This is what we deal with in the churches on a day-to-day basis. And again, it goes back to the hysteria of the real, horrible, but isolated events, and the hysteria from fantasy events that still people have in their memories that maybe there was something there that happened. So at that point, I realized, this was going to be an interesting case. And not only was my client charged with it, but there was another man also charged at the same time. He had gone to the same church. They had gone with the permission of the pastor. The pastor knew that they were on the registry. They had met individually with the pastor. They had discussed their offenses with the pastor. This was all in the context of a ministerial relationship, right? They were being witnessed to by the pastor. People in the congregation knew that they had these sex offense convictions in the background, and there probably were people that did not want them in the church, but there were people that did, and including the pastor. And they had even considered trying to accommodate these people so that they could come at other times to Bible study, to not be there when children's services or things were going on. They tried to do what they should to respect the law. But at the end of the day, they believed it was more important to witness to these two people and bring them into the congregation as opposed to shunning it. I guess maybe they believed in God. That was exactly So the good news for me and my client, the co-defendant, was there never was the other shoe to drop. There never was we saw him in the bathroom, we saw him in the children's area. None of that ever came out because it didn't happen. So we were very fortunate in this case. We have what lawyers like to call good facts. All he did was go to church. The evidence against him was people in church saying, we saw him. So, that and the guest had, shot in when we were there, which is a whole other issue about the church giving up information. So, in this case, we filed motions to challenge the constitutionality of these charges. They were charged under 2 sections in North Carolina. The premises restrictions have 3 sections. They were charged under 2 of them. One of them is that you couldn't be at any location where children gather for regularly scheduled educational, social, or recreational programs, whatever that is. And you couldn't be within 300 feet of any place primarily intended for the use, care, and supervision of a minor, if that location is located on a larger premises. So they were charged with 2 offenses for a single presence. And we challenged both of those sections of the statute, and to the elected judge's credit, he held those sections unconstitutional. Dismissed the charges. This was my first introduction to this interesting intersection of civil rights law and criminal law and social policy, and where those intersect, and where I as a lawyer can be involved in that. And also be involved in an area that is, at least then and still to some extent, is sort of like the Wild West. I mean, we have cases that come up and statutes and ordinances that are new, and this is unlike anything we've seen in history. So in many ways, this is a new frontier, and to me, I enjoy the challenge, and I enjoy the opportunity to help the stand. Ultimately, the state gave us an appeal. They were going to appeal it, and in the category of just unexpected things happening, the courthouse burned. I don't think it was related to the case. The courthouse caught fire, and then like 7 months later, the DA said, did we ever get a transcript in that case? And I said, yeah, we did. You missed all your deadlines. And so then we moved to dismiss the appeal, and the state withdrew their appeal because they had missed a lot of deadlines, and because I think they ultimately got advice from the Attorney General's office, which was, we've got somebody going to church, this is not a good case for an appellate review. But the problem that created for everyone in North Carolina was we had no appellate resolution. And unlike federal court, where like in the Adobe Cooper case, where the federal district court in the middle district held it unconstitutional, that was a statewide injunction. In state court, at least in North Carolina, the result was simply the charges were dismissed. So this order declaring the statute unconstitutional had no binding effect on anybody else's cases, nowhere else in the state. So it was certainly satisfying that I'd succeeded with my client, that I'd had the experience, but at the end of the day, it provided no relief for anybody directly. Indirectly, it started having effects. Because there were, as you can imagine, other people in the state of North Carolina who got charged with this new offense of services restrictions. And several of those cases wound up with the attorney in those cases using the motions that we had used in the church case and an order from the judge to persuade their local judge to the same result. And so we had a couple more cases in the state where judges found the statute unconstitutional. And in those cases, the state did properly appeal, and in those cases, I was able to get myself appointed to handle the appeal because I've had the experience in church case. So one of those was involving, and this is classic small town North Carolina, where the deputy assigned as the monitor for people on the registry knows everybody on the registry and can spot them, 300 feet away. And say, oh, okay, that person's on the registry, they're not where they're supposed to be. Maybe it's just the officers doing their job, but a lot of times, this is big run, right? So, my client in the local fair, the county fair case, was going, he can't be sacked up. He's going to the fair with his grandmother and some associated cousins. He walks up to the ticket line to go into the fair, and there happens to be an off-duty probation officer who's working security at the fair who sees him and realizes, oh, he's on the registry. Here's the fair. There's like a 6-foot chain link fence separating the inside of the fair from the parking lot. He's on the side of the fence in the parking lot. But somewhere inside this county fair, there are children's activities. There are things for children. And so he is at a place where they have regularly scheduled activities for children. He's within 300 feet of these locations. Two possible violations. So he was charged with that. He won the motion in the trial court to declare the statute unconstitutional, state appeal, and I got a sign on the appeal. Great, now we get in front of the appellate courts. So again, this is how appellate courts will avoid making decisions on the merits. Neither party raised any problem with the indictment, but the judges on their own saw a technical problem with the indictment and said, oh, the trial court didn't even have jurisdiction to hear this case. Dismissed. Great for the moment, right? My client had the charges dismissed. But again, we had no resolution on the big questions from the appellate court. Round 3 was my client who was charged with going to 2 different parts in Dare County, North Carolina, which is out of the coast. And in those cases, charge number 1, he drove to a county park. He was delivering some hunting balls to his grown adult daughter, who was there with her children, his grandchildren, who were playing field. They met in the parking lot outside of these fields. They spoke for about an hour and he left. Incident number 2 was at a city park where he was playing softball with a community team in broad daylight, full presence of everyone, and it turned out an umpire for a t-ball game was an off-duty sheriff deputy who recognized him over on the adult softball field. That was incident number 2. And for both of those crimes, I use air quotes for that, they went to his home with an arrest warrant, came in his home, tasered him as he came out of the shower, and took him to the county jail. What had he done? He met with his daughter in a parking lot. and he played softball on the community team. Now, the trial court judge in that case, to his credit, again, based on the success of the church case and the fair case, agreed with those judges and said this is unconstitutional. The state appealed. I was assigned on that case, and again, I'm thinking, all right, we got indictments that are good, we have the good facts, and so I made the same pitch that we ultimately made in Adobe Cooper and won with, and the Court of Appeals, incorrectly, in my opinion, held that my client didn't have standing to challenge the statutes on their face. And he could only challenge it as applied to him in those narrow circumstances. To the court's credit, they found that it was unconstitutionally vague, that third subsection of the statute, as applied to him, because you wouldn't know being in a parking lot could subject you to criminal prosecution in one case. And the same as the other, that being on an adult softball field nearby to a t-ball game would also not put you on notice that you were within the zone that was restricted. So, again, great result for my client. He had his charges dismissed. But again, we had a very narrow and limited ruling from the Court of Appeals. And, in both of those cases, I had won. So it's not like I'm going to go to the North Carolina Supreme Court and say, I won, but help me win better. Right? And the state didn't appeal to the Supreme Court in either of those cases. Probably wouldn't have been good for me had it done that, if you're familiar with Packing County. But that's how I've gotten here. And after that, I sort of have my name out there in North Carolina. If somebody had a case like this, they'd call me, we consult on it. Ultimately, what happened was, again, I got involved with the Packing County case. And because of these premises restrictions cases that I litigated, I was called by a client, and he said he was charged with using the internet. Again, I'm thinking, okay, what else? There's got to be something more here, right? You can't just be charged with using the internet. But he was. He had a MySpace account, and he had known when he pled guilty to his sex offense that he would not be able to then going forward under this law use those social networking websites. Here was catch-22. He feared that because that account still existed, he could be prosecuted. So he went on to MySpace to shut the account down, and that was the access that the state discovered when they investigated him and about 9 or 10 other people in the county when they matched up the registry against Facebook and MySpace. So that's what I was defending against in that case. It turned out one of the other people rounded up in this investigation, this Big Brother investigation, was Mr. Packingham. And he was represented by another attorney. And so I prepared a motion challenging the statute in my case with my client. And Mr. Packingham's lawyer did the same. We worked together. We filed our motions. We had about a 3-day hearing. And the judge rejected our time. Said it was constitutional. Fortunately for me, in my client's case, the district attorney used some discretion and accepted this defense, basically, which was I went on there to shut the account down. That is not some type of crime. And the DA dismissed my client's charges. So great for him, right? But I still didn't have any resolution on the statute. Mr. Packingham went to trial. He was convicted. And once he appealed, I was assigned as his appellate attorney to represent him on appeal because I'd been involved in the litigation of the trial court. I was familiar with it. I'd written the motions. And so at that point, we went to North Carolina Court of Appeals. We won. They said the statute was unconstitutional. And then the state appealed to the North Carolina Supreme Court. And they said, no, it is constitutional. And then now we're at the U.S. Supreme Court. And now I'm in Atlanta. That's how I got here. And it is a winding path, but it is something I certainly didn't expect when I went to law school that I would be here speaking today. But as I said, it has been an interesting journey that has been filled with civil rights litigation. It's been filled with criminal law and with social policy. And I found this to be very interesting. The next chapter turned out to be that somewhere around 2013, I think it was spring of 2000, maybe it was even 2012, I just started getting random calls from people saying, I want to go to church, and I'm not being allowed to go to church. I got calls from pastors saying we wanted people to come to their church, but the sheriff's office was saying they couldn't. What can be done? And, I am so busy with my practice and everything else, I'm thinking there's only a federal challenge really that can do this. I'm in private practice by myself. I don't have any kind of administrative assistant, no paralegals, no partners, no nothing. How was I going to take this on? And in walks Paul Dooley. Paul had just gotten off active duty in the Army and had done a clerkship in the 10th Circuit for about a year, and then moved to Hillsborough, North Carolina. He was asking around who he could network with in the criminal law. He was given my name. We had lunch, and I thought, here's a guy who has no practice, he got nothing but time on his hands. Of course, I had to build a relationship before I said, would you like to file a federal challenge? Because that's not something you usually would ask on the first day. But I thought this was important enough. And I said, well, you know what? I've got all this going on right now, and I really could use some help. Here's a guy who was really smart. He had experience as a federal clerk. I knew nothing about federal court litigation, but I did have his background in litigating these cases and familiarity with the North Carolina laws and statutes. So we teamed up, and it took us over a year to collect a group of plans, to put together our evidence and file a complaint. And then from there, the ball just kept rolling, and ultimately we won in no Cooper. In the interim, I had gotten offered this position as a North Carolina appellate defender in the fall of 2015, and it was an opportunity I just couldn't pass up. So now I'm not in private practice anymore, and I'm running a public defender's office. But the good thing is, all is still on the case, challenging the current restrictions, and I'm still representing Mr. Cunningham. And my office, because we have statewide oversight, I'm able to work with trial attorneys around the state to keep up with the litigation of restrictions. And when cases come to us on appeal, we've got them so that we can try to beat back some of these restrictions. So the constitutional problems that I started developing in all of these cases were really centered on the First Amendment and the Fifth Amendment. And these are common things you have probably heard in some of the other presentations. That we look at overbreadth, we look at expressive activity in public. I think there were some questions yesterday in one of the presentations about, why was O.D. Cooper a First Amendment case? Why did the judge find, based on the First Amendment, that being within 300 feet of a location was a restriction like that was unconstitutional? And what ultimately came out was that you have a First Amendment right. You think of free speech. You can say things. You can read books. You can write things. You can stay silent. That's a right, a First Amendment right to stay silent. But one of the First Amendment rights that's recognized is the right to be in a public place to receive information. So you go to the town park so that you can hear the speakers, so that you can hear the bands, so that you can be a part of the street fair, so that you can see these things and gather information. That is a First Amendment protected right. And what the judge believed was, and part of what we had asserted was, that if you're prohibited from being within 300 feet of these locations, you're not allowed then to receive that information and participate in that public discourse, whether it's in a public park or on the sidewalk. And those were the First Amendment grounds that the judge relied on. We've also raised Fifth Amendment vagueness. Most of these statutes they will write as broad as possible without any kind of concern for the consequences or what it means. They really don't care. They just want to banish people from as many places as possible. So those were some of the grounds that we raised in all of these cases, going all the way back to the church case. And we would try to put every one of these in. And then the practical problems that come up with this. I would routinely get calls, not just from attorneys, but from people in North Carolina saying, I want to go to church. I want to do this. I want to go to this place. And I have to say, I don't know. I don't know what this statute means, except what the officer in your town says it means when they arrest you or they tase you when you're getting out of shower. And that's the reality I would have to explain to people. I'm not judging you, and I'm not telling you you can't do these things, and I think it's unconstitutional. But the reality is, you have to live with this and do your best. That's about all I can say. So it certainly constrained me as a lawyer and as a counselor in how I could tell people what they could do and what they couldn't do. This was and again, this is just part of our litigation. We would typically put in easily made slides from Google Earth with 300-foot phones put around it. Visual images are persuasive. We had a session yesterday about using facts to persuade. Visual images also are persuasive because it shows immediately where a person can't go. This is Franklin Street downtown South North Carolina. These exclusion zones effectively keep you from driving down Main Street. You couldn't walk down the sidewalk, right? Because you've got the nursery, the museum, teen club. Downtown Raleigh, this is our state capitol, the Court of Appeals of the Supreme Court. If you're on the registry, you could not go to court. You could not go to the capitol. Right? And again, these are images which really show the stark reality of what we're dealing with. Here's a local mall, shopping mall. You have to kind of weave in and out of those zones. You want to go buy shoes, go to the movies. Hospitals, has anybody ever thought about that when they're looking at these restrictions? There's an entire thing called the Children's Hospital. Yeah. Right? It's attached to the Women's Hospital and the rest of the hospital complex. How do you analyze that? Are those single structures? Are they one big one? Nobody knows. Strip malls, is that a single structure? Are they individual? We had this question come up. Can you drive down that thoroughfare to the zone? And then we've got, and those are banishment. And then I should say the last one about banishment, which I'm going to touch on in just a few minutes, is prison. Prison is a form of banishment. Also a form of punishment. It's a form of banishment. It's removing people from society. And the General Assembly, the legislature, has made policy decisions on how long those prison terms should be. And for many of the restriction crimes, they're high, and especially for the registration violation crimes, they're high. So I think I'm going a little short on time. I'll get to some of the things here that really concern me now. The revolving door. The revolving door is the problem where you have someone on the registry doing everything they can to try to survive, but they violate a premises restriction statute. They get a job at the mall working at a kiosk, and then one day somebody comes to arrest them and says, didn't you know the kiosk was within 300 feet of the children's play area? That happens. They go to a church to talk to a pastor during the week about getting an angel tree set up somewhere in town so the children can get presents at Christmas. You know what? There was a nursery, a daycare that was there at the church during the week. That's a premises restriction violation. That's a real case. The vast majority of these cases where there are restriction violations have nothing to do with somebody doing anything wrong. other than being it somewhere where they're told they're not supposed to be. But what this does is it creates a revolving door of banishment. You know, you go into prison for 8 months because you went to church. You come back out. You go into prison for 6 months because you were on the internet. You come back out. You don't change your address when you move across the street. You go back into prison. Otherwise, law-abiding people are caught up in the revolving door of the criminal justice system. And this is without any requirement of intent. I mean, I'm not talking about the people who truly are trying to evade law enforcement and the registry. There are probably people who try to do that. I'm talking about the people who they get kicked out of the apartment because they can't afford the rent. So they move in with their mom. And they don't go to the sheriff's office to report that. I'm talking about the people who don't have enough money to have their own apartment, so they sleep on the couch with their girlfriend 3 nights a week, and they stay with their brother 4 nights a week. Where do they live? What do they register? You know, we all run into these practical problems with cases like this. And this turned into a revolving door. And the arbitrary and disparate enforcement. We've got 100 counties. I don't know how many law enforcement agencies in the state. At least 100 sheriff's offices. And, you know, just being involved in this litigation, I've learned that in one county, the sheriff sends out a letter that says you cannot go to church in this county if you're on the registry because of premises restrictions. Another county, they say, oh no, church is fine. You can do it. So you've got revolving doors for arbitrary reasons. And so the legal challenges, we talked about premises, we talked about the internet. Some of the new ones we're working on now are satellite-based monitoring. In North Carolina, there are offenses which qualify a person for a satellite-based monitoring device, which is GPS tracking on the leg. It has to be worn for life or for a term of years. We did have success. The United States Supreme Court sent back one of our cases and said this is a Fourth Amendment covered search. So we have hope with satellite-based monitoring. Grady versus United States. Versus North Carolina. Grady versus North Carolina. And the state's position was this was not a search. This was obviously a collateral consequence of the conviction. This is a civil civil remedies for people being bad. This is not a search. Well, the United States Supreme Court, in a per curiam opinion, was very late. Said, no, this is a search. If you put a GPS device on a car, that's a search. If you put it on somebody's leg, it's a search. So we are now litigating what is reasonable. And we don't know where this is going, but we're working with trial attorneys around the state. We have some of the cases in my office on appeal. We've got briefs filed in the Court of Appeals. And then residential restrictions in North Carolina, we've had no real challenge to those. In some states, I think we have. So, as part of the wide-ranging presentation, I'll give you some of the factors I've seen that have led to success and change in North Carolina. I would hope that these could be translated to your state situation. You need to have attorneys that care about the issues, advocates that know the law and the nuances. These are complicated statutory areas. Trying to figure out the removal process from North Carolina registry is like decoding, a code from World War II. Compelling stories, critical examination of statistics, elected judges who have courage to do the right thing, federal judges who also have courage but don't have that fear of election that comes up every 4 or 8 years, and then regular communication between trial and appellate law. This is one thing that I don't know how things work in your state. We've got 50 states. We've got a lot of different ways things work. But in North Carolina, we have a fairly good coordination between the trial and appellate bar. And that's one thing that I try to do in private practice, and now with the health center I'm trying to do, is make sure we're all on the same page with these challenges. We have spreadsheets set up trying to track cases around the state. We try to monitor litigation. We try to push out information to trial attorneys to assist them to set the case up for appeal. Because if it's not set up right for appeal, especially in a criminal case, it's going to be dismissed or they're going to rule on other grounds. And then emerging issues that I think this organization and others can take on. Obviously, pushing back through lobbying against additional and modified restrictions, using statistics and helping attorneys to understand and learn about the statistics. I've learned a lot this weekend about that. Seeking success stories. I see that project here that seems to seek some of those. Engage the community to reduce isolation. This is obviously, a part, I think, of the big picture.
Yes.
This big picture is not just about let's get rid of restrictions, let's get rid of registration. It's also let's work to reduce violations of the restrictions and recidivism. And that will only improve the image of this organization and the people that are subject to restrictions if somehow we can work together to reduce recidivism. It's in everybody's best interest to do that. And that includes trying to reduce isolation. Now, how does that happen? I don't know. Do local groups reach out to people and say, we are here for you? I don't know. This is beyond me. This is the social science part of it that I don't know. Support groups to reduce isolation. What can this organization do to help people that are on the registry and reach out to people that are not necessarily helping themselves? Lobby for funding for counseling for those in prison and on probation. North Carolina has a fantastic program called the SOAR program. It's only in one prison. It's very limited in the number of people they can take, but the success rate for people once they leave prison is phenomenal. It's the kind of thing that if it could be replicated in other prisons in North Carolina, would be fantastic, but there's just not funding. And the same with counseling for people on probation or parole. Engage partners in common interests, whether the ACLU, faith groups, the NAACP,
yeah.
And then work to reduce technical violations of registration requirements. Again, I don't have the answers to how to do this. I am simply saying that as a public defender and as a private practice attorney representing people appointed to me, I would time and time again see people charged with technical registration violations, going in and out through the revolving door of prison. And yes, the laws are strict. Yes, they should be changed. But it can also start on the front end to simply try to reduce the conditions and the problems that lead to those violations. I've also seen a racial disparity in these cases. And again, I don't know if that is part of this organization's mission to try to understand that. But it is also a poverty issue. And the vast majority of people who have the restriction violations and especially the technical registration violations are poor and people of color. And I'm not a social scientist. I don't know why that is. But it is similar to everything else in our criminal justice system, which has resulted in mass incarceration of the poor, underprivileged, people of color. And this area of law is no different. So to the extent that this organization can make efforts, like others have done, to try to address those problems, I would think that would be something worthy to pursue. How long do you want?
5 or 7 minutes.
Okay. I can give you one other example of litigation in North Carolina, and then we can open up for questions. So, in North Carolina a few years ago, they created, and this may be something to look at in your state to see if you have it, post-supervision release. It's basically a fancy name for parole. We don't have parole in North Carolina, but we do have something called post-supervision release. And what happens in those cases is that when you get within 9 months of the end of your maximum sentence, you get released. So there's 9 months of prison time still hung over your head for 5 years when you are released from prison. What North Carolina was doing is someone was on that post-supervision release and they violated the terms of it, they could be sent back to prison for any part or up to that entire 9 months. That's what makes sense the way that works. What they were doing, though, with people who had sex offense convictions was they would send them back for the 9-month return to prison for a violation. And one day before that 9 months expired, they would be released. One day early. Because in the post-release supervision statute is a provision that gives the post-release supervision and parole commission, because we have parole for very old cases, we still come to the system, but not anymore new ones. The post-release supervision and parole commission could hold a criminal contempt hearing for violations of your post-release supervision conditions, which are very similar to probation conditions. And so what would happen is the person would violate for some technical reason. They would go to prison for the remainder of that 9 months, but get released one day early. That one day would be held over their head, and for 5 years they could be subject to contempt for violating any of the conditions of the post-release supervision. So instead of saying you violated the terms, go back and do your 1 day, they would be given 30 days, which is the maximum for criminal contempt. So there were people in this revolving door of criminal contempt. They get released, come back 7 months later, criminal contempt, 30 days in prison, get out. This was just, it's draconian. Everybody's shaking their head. Right?
Money making.
Oh, sure. I'm sure there was money involved. I'm sure there was money involved. Also, people like power. And the parole commission, post-supervision release commission, liked the power of this. And so what we uncovered was that these contempt hearings were being done without a real opportunity for court-appointed counsel. And so we started pushing the state to require an attorney to be present, to be available for someone who was charged with contempt. Because nobody was trying these contempt cases. These people were just basically signing away saying, all right, I'll go do 30 days and get out. So we have beaten that back because the state is now ruling that they started giving people attorneys for these contempt hearings. And once that started, people started saying, I'm not guilty of contempt. I want to trial this. Then suddenly it's, okay, we're going to not go through this process of having released with 1 day left. At least for now, we have successfully beaten that back. But just an anecdote about how, again, this is all wrapped up into the registry. There was one client who had this happen. He was sent to prison for a 30-day contempt. He got out. He went back home where he had been living. But you know what he didn't do? He didn't register his new address. His new address was the address he had before he went into the 30-day contempt. He was convicted of it. He was habitualized as a habitual felon, and he got 7 years. And we've got that case on appeal. I'm sadly not optimistic, but we have now hopefully at least removed this draconian tool from the state, this 30-day contempt sentence from their tools. So that's where we are in North Carolina. That's how I got here. That's how we all got here. And I'm open to questions. I certainly don't have all the answers for you.
I got 1 second, please. Wait. To the microphone, please.
I admire you because you're not one of the crooks getting paid. You're out here trying to help people because you really care about people. Most of these crooks in here, they're attorneys, they're all about money. When I make $900 a month in Social Security, when this happened to me, I was 74 years old. I had to get a bond. I didn't have the money, so I had to sell things that I owned. Nobody gave a damn. They still don't. But I had to go get an attorney. If it hadn't been a drug guy in the jail that I was in that helped me get his attorney, my question is, what can we do? What NAACP back in 1963 because I wanted to get out and do something about what I thought was wrong.
Well, what I can tell you is, I'm encouraged to see everybody here tonight, and it's slow. The arc of history bends towards justice, right? But it is a slow process. And unfortunately, it is too slow for a lot of people. The client who's in prison for 7 years for not registering his address, which was his old address. He's a victim of this. But 10 years ago when I started this, I had no idea about other people in other states and issues and things, and here we all are today, and it's moving. It's just not moving fast enough. Working for access to justice through legal aid programs or public defender offices, trying to find out, again, who are the people in your state, like me, like Paul Doodling, people that are interested in these issues and capable of doing it and are not necessarily in it for life.
I have a son who's in prison for 25 years who was an intern. I have become aware as a psychologist myself of the fact that confidentiality keeps people from getting the treatment that they need. And I'm thinking that we need to change our confidentiality laws in the United States. Do you know of anyone who's doing that? Or is there any movement toward that, or anyone who's working on that?
I don't. I'm not familiar with any efforts to do that. I am familiar with challenges that clients have, like we heard about yesterday, with people having to reveal past offenses and things as part of probation and polygraphs. But I'm not familiar with that. Okay. All right.